Anyone know why? Right. Absolutely. So automatic survivorship rights. So they hold title in what's called tenants by the entirety. And that does have the automatic survivorship rights between the two of them. So as long as the individuals are on the deed as a married couple, you can say and spouse or married couple, you have those automatic survivorship rights between the two of them. So the minute Kanye dies, at time of death, by operation of law, his interest passes to Kim. We're not worried about what Kanye's will says. So this is kind of the best case scenario for your seller when they come to you and say, oh, my husband recently died, I want to sell my house. If they tell you, and obviously have the attorney check it out, but if they say, oh yeah, my husband and I were on the deed together, then you're thinking, oh good, okay, we can sell this house right away. The only thing we're going to ask for in that situation is a death certificate, proof of death, which we can probably pull from the county anyway. So that is going to be the tenants by the entirety. That's going to have the automatic survivorship rights. So you are correct. The answer is we're not worried about Kanye's estate. Now, the second part of this question, would this answer change if Kanye and Kim were granted a divorce prior to Kanye's death? So they're still on the deed as husband and wife. No one's changed the deed. They've just gotten divorced. Then Kanye falls off the stage and dies. Is that going to change our answer?
Mm-hmm.
Depends.
Depends. Okay, we got a depends here. You say you're definitely going to change the answer? Okay, all right. So you're thinking the tenancy by entirety only applies if you're married, right? That is correct. That does change our answer entirely. A divorce severs the tenants by the entirety. So if that divorce is legally granted, not just legally separated or pending, you have a legal granted divorce by the court, that severs the tenancy by the entirety. All of a sudden, this is an entirely different ballgame here. We've got Kanye, Kim not getting the automatic interest, and we do have to worry about Kanye's estate.
So if it's 50-50 ownership at that point,
it's still 50-50 when they're married, but the law does sort of treat the tenants by entirety as one unit almost.
Yeah.
But right, that severs it, and then it just makes it 50-50 tenants in common. And we'll talk more about tenants in common.
So if Kanye is not dead and he's still on the deed and they're divorced,
mm-hmm.
does he still have to, and they sell the property? So they both still need to sign everything.
They still need to sign everything.
That divorce doesn't take away anything about that, only if he's dead.
Nope. And so if he dies after the divorce, that tenancy by the entirety is gone the minute the divorce is granted. That severs that tenancy by the entirety. So the bonus question here is, what is see if anyone knows the answer to this one. What is the other primary benefit of holding title as tenants by the entirety? There are two major benefits to that, holding in that tenancy. One is the automatic survivorship rights, which is a nice automatic kind of estate planning tool. What's the other benefit? Anyone know the answer to that one? Mr. Horgan? Sometimes I'm explaining the deed to clients. I'll go through this. Sometimes I don't always. But.
I feel like I should know this.
Does it pass to the heirs automatically?
Nothing to do with heirs. Has to do with judgments. That's it.
That's right.
Yeah. Okay,
the spouse is protected. The house is not up can't be attached to the judgment.
Right.
If one party is sued, as long as both parties aren't sued.
So that situation is you're holding title as a married couple. You're both on the deed. Listed as married. Regular civil judgment against one of you doesn't attach to the house unless it's against both of you. As long as you're still married on the deed as a married couple, it's kind of the tenancy by the entirety judgment exception. Now, there's always an exception to the exception, right? And that's a federal tax lien. That's North Carolina law about a civil judgment will not attach to the property. It's only against one spouse, and they're both on the deed as a married couple. A federal tax lien or a federal judgment pierces that. That will attach to that person's half of the property. So we see an IRS tax lien, we're like, doesn't matter if they're married or not, that's going to attach. And what I mean by attaching to the property is if a judgment's filed in the county where that person owns the property, it will attach to that property unless you have some other reason why it doesn't. And by attaching, that means that person goes to sell the house, they have to pay it. It's a lien, right? It's liened is like a deed of trust.
So if you have clients who buy a house together and are not married when they buy it, but they're engaged, once they're married, as a service, as their agent, you should be reaching back out and say there's a reason, even though you both own that house now that you're married, you should redo the deed to have it done by tenants by the entirety, right?
Yeah, you stole my thunder.
Yeah, because of that. Oh,
that's okay.
I want to make sure I related it to how we can be the
that is the
hero
practical
of the
application. Yeah. Absolutely. So to follow up on that, you've got a couple who's buying a house and they're engaged and they're saying, "Oh, we're going to get married 6 to 8 months from now." then what Brian is getting to is you need to at least mention to them, hey, you should speak to the attorney, your closing attorney, about maybe getting a new deed done when you do get married, so you do get that tenants by the entirety protection. So yeah, that's a good.
So
practice.
set yourself a reminder to
Good
follow up with them in
practical.
8 months and tell them that.
That's good customer service.
It's an
right
easy
there.
touch to the client.
Hey,
I mean,
congratulations for them. You guys got
Yeah.
married. Congratulations.
Don't
forget to
forget.
go back to your deed change.
That's right.
So even if the spouse is not going to change their name, you still want to get the deed changed.
What would
to
it
get
have
that.
been while they were engaged? Because I actually do have a couple like that. It's not tenants in the entirety.
No.
So
Tenants in common, right?
if they have two options on how they can hold title. They can hold tenants in common, or they can hold joint tenants with right of survivorship. So there is a second option there that gets the survivorship rights. But why you still want them to go ahead and follow up getting the new deed is to get the judgment protection. That doesn't kick in automatically by getting married after the deed. So another little sort of grim bonus question here: if two individuals are on a deed as husband and wife, and the wife is convicted of murdering the husband, does she still get his one half of the property?
Yes.
So it is tenants by the entirety. You're going to say yes.
But she'll be in jail, so.
So it's not going to help her a lot. She's in jail. There's actually a Slayer statute in North Carolina. You would think that would just the half would pass, but I think that Slayer statute does override that tenants by the entirety law, and the spouse would be blocked from getting that half of the property because of the Slayer statute. So hopefully you won't run across that scenario in your line of work. You have some questionable clients there, right? Alrighty, so we may have just. Oh, let's see. Okay, no, we'll go down to the next one here, and you may know the answer to this one based on what we just mentioned, what we just discussed earlier. Same facts as above. This is the Kim and Kanye buying the house in North Carolina. Kim and Kanye are married and both going on the deed as one half owners. But Kim, upon her death, would like her half of the North Carolina property to go to her sisters. And Kanye, upon his death, would like his half of his property to go to Donald Trump.
Oh, Lord.
Yeah. Ooh. So, do Kim and Kanye have to go through a costly and highly publicized divorce? TMZ would love that, but to achieve this result. So they're married, they're buying this house, but they don't want that automatic survivorship rights. Kim wants her half to go to her sisters. Kanye wants to go to Trump. What do you think our options are here? Or do they? It has to be husband and wife on the deed. Got to have the tenants by the entirety.
No, you have to have a will at that point.
Well, see, a will wouldn't override the tenants by the entirety because that's automatic survivorship rights. But there's another way. We just mentioned it a little bit earlier.
The own it by tenants or tenants in common.
Right, and you can specify that. You would have to list that. You would have to say Kim 1/2 interest, and Kanye 1/2 interest as tenants in common. We're going to override the husband and wife automatic tenants by the entirety. We're going to list that as tenants in common. So that is an option. A married couple does not have to take as tenants by the entirety. The vast majority of the time, that's going to be what they want to do. It makes sense. You probably want your half to go automatically to your spouse, but it doesn't have to. So we can go tenants by the in common there. And once we get tenants in common, then you're right. If that 1/2, Kanye dies, that 1/2 could be covered by will or who would inherit the property.
So that might be more common in a second marriage and a second home, right? Where like maybe they say, well, we want our portion, our ownership to go to our children from our.
Absolutely, second marriage, you could see that where there's children from a prior marriage and they would want their house to go to them. Absolutely. So yeah. Good.
And do they need to have talked to the closing attorney about this ahead of time? Is this something you can handle at the closing
We
table?
can handle the closing table. That's just a quick change to the deed. So I always, in my closings, you'll see at the end of the closing, I always review the deed with the buyer and I go through how they hold title, about how they don't need the original deed. It's going to be filed. You don't have a safe to put the original in. So that is something I cover. So at that point, if we talk to folks and they say, oh, we do want the survivorship rights, or no, we don't want the survivorship rights, we can make those changes at closing. Not a bad idea to discuss it beforehand. But another point too that just popped in my head, we were talking about earlier about the judgment protection. If you have a property investor, let's just say they run kind of a high risk type job too, just somewhere where they might get sued, and they're saying, okay, I want to buy this house, and they're married, but they say, I want to buy this investment property, I just want it to go into my name. Well, that may not be the best idea ever if they've got like a high risk job where they could get sued, and they have a spouse who they could add to get that judgment protection. So another thing where obviously you don't want to give legal advice to them, but you could say, oh, you might want to speak with the closing attorney about You know, maybe if you're someone who could get sued and you're the only person on the deed and you're not putting it in an LLC, then you're opening yourself up to having a judgment attached to that property. Whereas if you add the wife and she's not someone who's going to get regularly, sued potentially, then you've protected the property that way. So something you want to sort of point the buyer in the direction of speaking with an attorney about.
John, what would be the charge if someone was like engaged when they got married and then wanted to change that type of ownership?
So our regular deed prep fee is $125, but for that, in that situation, if we did the closing, I always tell those folks that, look, if you come back to us to do the deed, it's $75 plus what the county charges to record. So we give them a $50 discount. So $75 and the county charges $26, puts you right around $100 to get that done. So it's not a huge expense to come back. And that person can just contact our office, set up an appointment to come back in and sign the deed and create a new deed. Putting them on the deed as husband and wife.
So $125 if they didn't use you.
Once we've got our regular deed prep, if you just have somebody who hasn't worked with us before, but they need a deed.
Because here it says 75.
That's when we're doing the seller side.
Oh, gotcha.
So when we're doing the seller side, our seller doc prep is $175. That includes the lien waiver, tax forms, everything. So if you've got sellers who aren't comfortable with the buyer's attorney doing their paperwork, it's actually kind of a nice feature to have the seller have their own attorney sometimes. Sometimes it's easier to let the buyer do all the paperwork, but the buyer's attorney. But sometimes if you have a seller who's a little worried that they'd like to have their own representation, for that $175, that sort of gives you another resource of that seller being able to call our office. Yeah, we're preparing your deed, but we'd be glad to answer a contract question for you as well. Doesn't mean we're going to go into full-scale litigation with the buyer. That would be getting a different attorney. But it does give that seller that resource of not having to go to the buyer's attorney and ask them a question about their interest in the transaction. Because the buyer's attorney at that point is going to say, hey, look, I can try to answer your question, but I'm the buyer's attorney. I'm not representing you. So, but basically the same cost. I think all real estate attorneys are somewhere between $150 and $200 or so on the seller doc prep. Your seller gets their own attorney that way. So.
Just be aware that some attorneys, if you have your seller use a different attorney, they charge a fee
For the seller CD.
And so
We don't do
it
that.
ends up correct, but it ends up costing more money than it would have.
Right.
I've seen it a couple of times. I don't think most attorneys do it, but just be aware.
I have
of
seen
that.
that. You're right, and it's usually like $50.
Yeah, so like if you use us, it's $200. If you use another attorney, you're going to pay that other attorney and a $150 fee from us for having to coordinate with another attorney's office.
Something to watch out for.
Yeah.
And because you're doing the seller CD, and I have seen that. That's
Yeah.
a good point. All right, where did we leave off here? Oh, we're down to section C here. So we moved to Kendall Jenner here. Kendall Jenner and her boyfriend would like to purchase a home in North Carolina with both persons going on the deed as one-half owners. Kendall has been too busy eating salads to get a will done. Kendall does not trust her sisters, and upon her death would want her one-half interest in the property to go automatically to her boyfriend. Does Kendall have to rush into an ill-advised wedding with her boyfriend to achieve this result? So Kendall doesn't want her half of the property to go to her sisters or through the will. When she dies, she wants her one half to go to her boyfriend, who's also going on the deed. Now, they're not married.
Tenants in common.
Automatic rights of survivorship.
Joint, yeah, we discussed it earlier. Right, that's the right answer. Joint tenants with right of survivorship is what that is called. And that's something we can add to the deed at closing as well. Anytime I'm doing a closing, it's an unmarried couple. Two people buying the house and they're not married, I'm going to automatically ask them, do you want to hold tenants in common or tenants, joint tenants with right of survivorship? So. And the bonus question here, we may have already covered this, but I'll go through it anyway. Kendall and her boyfriend buy the house in North Carolina and go on the deed as one-half owners with no additional language regarding how they hold title. Kendall and boyfriend get married 1 week after the deed records. After the marriage is official, do Kendall and her boyfriend now hold title as tenants by the entirety with automatic rights of survivorship? Went on the deed unmarried, then they get married after the deed. I think we covered that earlier. That does not automatically, the marriage does not automatically make them tenants by the entirety. They got to go back and get a new deed drawn up to put them on the deed as husband and wife. That's not going to happen automatically. Alrighty, so we'll go down to the summary here. And so the summary here and if you remember, this was the first section, which is do we need an estate? Holding title as husband and wife on the deeds, called tenants by the entirety, creates automatic survivorship rights between the two grantees. We do not have to inquire about a will or an estate file when one spouse predeceases the other. Now, if they die at the same time, then you still got to worry about an estate, because if they're tenants by the entirety, but they're in a car accident, they both are killed at the same time, then obviously the property can't. I think even the law has, like, if it's within a certain amount of time of each other, they still count it as simultaneous death. So if you legally prove the husband went through the windshield and died 10 seconds before the wife did. I think they still can treat the law up to a certain point trace out a simultaneous death, and you don't have the survivorship rights that kick in there. And even if you did, you still got the wife passing away. So hers, whoever died second, you still got to worry about their estate. So, all right, the second part here: a divorce severs the tenancy by the entirety and the automatic survivorship rights. Other ways you can hold title on the deed: tenants in common. We talked about that. This is a situation where two owners, but those owners want their half of the property upon their death to go down through their estate. They don't want it to go automatically to the other person. That's tenants in common. Joint tenants with right of survivorship. There's also a life estate. That is where you grant someone lifetime rights to the property. It's called a life tenancy, and then you have a remainder. So that kind of works in a situation where you maybe have a mom and a daughter, and daughter wants mom, but for maybe to avoid something about Medicaid or something, she doesn't want to be an owner. The mom doesn't need to be the owner. So she would take a life tenancy. You would do the deed to mom as a life tenant with lifetime rights to the property, remainder to the daughter. That would mean right upon the mom's death, property automatically goes to daughter. In some situations, the law may not treat the mom as the owner. They'll treat her as a life tenant, and that can be advantageous. So obviously, you would need to point a buyer who's interested in that to a estate planning type attorney or an elder law attorney to make sure that's the right tenant, the right type of ownership for those individuals. And also, a property can be held in a trust. Obviously, if a property is held in a trust, we need to get a copy of that trust, get it to the closing attorney. The trust may dictate what happens when someone dies. So if the beneficiary of the trust is deceased, trust owns the property. In all likelihood, the trust is going to dictate who got the property after the person died. It's not going to go into an estate in all likelihood. Some trusts can pour over into a will and you still have an estate. But the big thing you want to remember from a practical standpoint with trusts are your seller's telling you the property is owned by a trust, but someone in the trust has passed away recently. Then you need to get a copy of that trust to the buyer's attorney so that we can review it and see who does own the property pursuant to the trust. So.
When they need to get that trust before listing it, right? Because you don't even know if that person has the right to sell the property for the trust.
I'd get the trust reviewed before listing it, because who's going to go on the contract? Yeah, if the trustee's dead, there may be a successor trustee who would need to sign. If one of the beneficiaries has passed away, then maybe the interest in that property that was in the trust went to the children, and they would need to be the ones to sign. So, that's a good point. Alrighty, so we'll jump into the second part here, which gets a little more complicated, which is estates. So this is the situation where we don't have one of those automatic survivorship rights. This is where we do have a property that has passed into an estate, or it's technically passed into an individual, but it's still in an open estate. So the first question there is going to be, did the individual property owner die with a valid last will and testament, which will be called testate, or did the person die without a valid last will and testament, and that's called intestate. So those are your that's your baseline question when you're talking about a property that's gone into an estate. So we'll first tackle the intestate part. So this is your person, they'll just say, just for ease here, the person owns the property just in their name. They pass away, and the property is going to be sold. So obviously the first question is, was there a will or was there not a will? If there was not a will, then it's intestate, and we're going to run through that. So this is a situation where there is no will. So we've got Joe Careless and Wendy Procrastinator here are married with 5 children. Joe bought a beach house in North Carolina in his name only before they were married and has not added his wife to the deed. Joe does not have a will. Joe and Wendy forget to get the brakes fixed on their car, and just Joe's in the car, by the way. And Joe drives off a cliff and plunges to his death. So who gets the beach house? We've got the property just in Joe's name. Wife was not on the deed. Joe does not have a will, and Joe's dead. So if you're the listing agent on this one, okay, who are you going to have to deal with? So got any ideas on who gets those? He's got a spouse and he's got 5 children.
The next of kin would be the spouse, right?
You thinking spouse gets it all?
Yeah.
You think the kids get it all? Any other answers out there?
I think the spouse maybe.
You
But
think
I
the
think it
spouse?
has to go into probate for a while.
Yeah.
That would be correct. Yeah. So we got another vote for spouse. It's actually going to be both. So the spouse is going to get 1/2 of the real property. The 5 kids are going to split the other half. So that's going to go halvesies on that one. So the bonus question on the next page, and I put a chart in here you can look at. You're certainly welcome to review and hold on to. that gives you a pretty basic idea of how inheritance law or intestate succession law works in North Carolina. The bonus question is, one of Joe and Wendy's 5 kids was legally adopted. Does that child get an intestate share?
Yes.
You say yes, that's correct. They would. Yeah, legal adoption. Not, it has to be a legal adoption, but that kid would be included. So subsection B here, same facts as above, except Joe and Wendy procrastinate as usual and have not gotten around to having any kids. Joe is survived by his wife, his conniving brother Owen opportunistic, and stodgy mother Margie battle axe. Who gets the beach house? I.e., does Wendy have to deal with these lunatics?
Yes.
So we got a wife, a surviving mom, and a surviving brother, but no kids. Joe's got no will. He owned the house just in his name, and he's unfortunately gone off the cliff. So who are we having to deal with here? Who gets the house?
I
Half
think
of
just
it.
the wife.
No, it's 50-50 still.
You think it's 50-50 who gets the other? The wife obviously is going to
Yeah.
get 50.
Yeah, wife probably gets half and then the quarter for the mother and brother.
No,
You
mother.
think part to the mother, part to the brother?
Mother.
You think all mother? That's
Yeah.
correct. So it goes half to the wife and half to the mom. So yes, Wendy is going to have to deal with Margie Battleaxe, unfortunately.
If the mother is not alive, then the brother gets the other half. Whoever the next sibling gets whatever left, right?
Yeah, it gets a little more complicated once you get past, and the chart will help you with that. It gets a little more complicated once you get past spouses, but this is another good segue into here for you folks out there and people that you work with who don't have wills. You can see here that you can get a pretty unexpected result from intestate succession laws if you don't have a will. I think most folks would think that I'm married and I don't have, and my wife will say my wife's not on the deed. I think most folks will say, oh, well, don't worry about it. That my wife will get it, all my house, if I die. Well, she actually won't. She may have to split that house with your mom. So, good reason to get a will done. So I'll throw that out there again. Some of our office can help you with there as well. So you do get some odd results here from the inheritance laws in North Carolina. So that covers that.
I have a question.
Yes.
So, say like a husband and wife are married,
Mhm.
and they go to buy a house.
Right.
The husband is only on the loan.
Okay.
The wife can still be on the deed,
Sure.
just the same as,
Sure.
okay,
She'll need to show up at closing though, because
Yeah.
she'll have to sign a deed of trust and a few other documents. That's correct.
okay.
You can have very rare where a lender's going to say you can't have a spouse on the title who's not on the loans. You see that quite frequently, actually. Where if you see a couple buying a house and they can qualify the loan just in one of the spouse's names, sometimes you'll see that pretty often that one person's on the loan, but they're both going to go on the deed. So, but just make sure both parties come to closing. If they're both in the deed, you'll hear the one to buy. You hear that one to buy, two to sell. That you'll hear that sentence a lot. That's the situation where you got a married couple. One person's buying the house, getting the loan, but the other spouse is not going on the deed. So that's a different situation than both going on the deed. In that situation, with the lender's approval, you got to check with the lender's underwriting. You can have a buyer who's married come in, buy the house just in their name, and you may not need the other spouse to come and sign. If it's just the deed going into that one person's name, they're the one person in the loan. Other spouse is not going on the deed, not going on the loan. That's the kind of the one to buy. But I will caution you that you need to have the buyer check with their lender. Some lenders underwriting will say, we don't care if the wife's not going on the deed. We want her to show up and sign the deed.
She's responsible for repayment too, right?
No,
She's not personally obligated on the loans because she's not going on the loan. She's not personally obligated. And actually she's not, because she's not going on the deed, so she wouldn't even be foreclosed on. Her interest wouldn't even be foreclosed on. But obviously that spouse passed away and no one makes the payments, then the property's going to get foreclosed on.
Yeah.
That's the whole one to buy that you hear sometimes. That's the one buyer spouse not going on the deed.
does the other spouse have to sign off their rights to that, or no?
They do not have to. You're correct in thinking that spouse does get marital rights.
Right.
That's the two to settle.
Right.
So absent some agreement that waives that person's marital rights in that property, you still need that spouse to sign when you resell it or refinance it.
Okay,
That loan can be refinanced. So you're right, marital rights still attach.
okay,
It's just a question of, does that spouse have to show up and sign any of the loan docs? because they're not going on the deed and not going on the loan.
So if he died, she would still inherit the 60,000 plus.
It would depend on whether she had a will. If you're talking about one buyer here, it depends on if that person has a will. Their will would dictate who it would go to if there's a will. If not, it depends on if there's living children. If there's no children, is there a living?
You kind of see that in investment properties and things like that when they do.
Where you just see it go just in one person's
Yeah.
name. Yeah. You just have to advise that person that, look, if you're married but you're only putting in your name, and they may have their reasons for doing it, but you're not getting that judgment protection, and then it's going to get complicated when you die because that property's not automatically going to go to your spouse. You need to add your spouse to get this automatic survivorship right. But the problem may be that their spouse has a judgment against them, or and if you're married and your spouse has like an IRS tax lien against them, you wouldn't want to buy the house in both of your names. That IRS tax lien would immediately attach to the property. So that would be a situation where it makes sense for only one person to buy it, even though you're married, because your spouse has an IRS tax lien. You don't want that lien to attach to your house. So it would make sense in certain circumstances. Or I think you were saying earlier, like a second marriage is a good example of that too, where you may not want your half to automatically go to your spouse because you've got kids from a prior marriage who you want to devise the property to. Alrighty, so we're going to flip past the chart here, and I don't know what we're like on time here. An hour, everyone's good. I guess it usually takes about an hour to get entirely through this. So the practical application here is, and this was from a real closing. So you are the listing agent here. You're listing a property for two sellers who inform you that they are the executors of their deceased father's estate. So you had the dad who owned it. He died recently. So now you're listing the property, and these two folks here are telling you that their father devised the property to them. They inform you that they are authorized to sign all the paperwork, including the deed for the estate, and that they will be present at closing. So we send out our little seller information sheet, and it was marked on there, sellers will be present at closing to sign. So in our mind, we're thinking, okay, the sellers will be there. The closing attorney sends you seller information sheet, and you mark that all sellers will be present at closing. The closing attorney's title research reveals that the property was actually devised to 4 children, and the executor's siblings also need to sign. The two sellers arrive at closing, and the closing attorney asks where the other 2 children are, and also if all the spouses are present. The other 2 children are in New Jersey, and the closing has to be rescheduled for the following week. So how could this have been delayed? When I look at this, I don't think you can blame either party. It's a lack of communication between the listing agent and the closing attorney. So the closing attorney could have easily reached out to the listing agent and said, hey, let's just make sure all 4 children and their spouses have to sign. The listing agent easily could have reached out to the attorney and said, okay, the seller told me that these 2 individuals had all the authority to sign. Is that correct? Is that the 2 people need to sign? And we could have said, no way, there's 4 children who need to sign, plus all their spouses have to be there. So it's really just communication. So my big warning here would be, when you're dealing with an estate situation, don't trust what the seller tells you. You're going to get an executor who tells you, oh, I'm authorized to sign everything. Well, wait a second. Check with the buyer's attorney who's pulled the estate file and say, is that true? Can the executor sign everything? It's very rare where the will gives the executor the absolute authority to convey the property. Usually all the devisees and their spouses have to sign. Don't forget about spouses here. So when you're looking at a purchase contract, from a very ideal situation, you would want the executor to sign it. If you're on the listing side here, you'd want the executor to sign it, and you'd want all the children who got it in the will to sign it. If you want to be super cautious, you want all the spouses to sign it. I mean, that's a lot of people to put on the contract, but depending on how many people you have. But to cover all your bases, if you get all the spouses and all the children to sign plus the executor, then no one can come back later and say, oh, I'm not going to sign the deed. I didn't agree to sell the property. And then all of a sudden you got a spouse who's held the whole thing up. If they sign the purchase contract, then it's like, well, sorry, you're bound by the contract. You did sign it. So in an ideal situation, I know it's not, I don't see that happen every time, believe me, but from a very ideal situation, at the very least, don't just get the executor's signature on the purchase contract. If you know there's other children who have to sign the deed, get them all to sign the purchase contract. And if you can get the spouses, all the better. So yeah, the delay there could have been prevented just by taking one extra step of asking the closing attorney, is this correct that only these 2 folks need to sign, or are there more people who need to sign? So, because we're going to search the title, we're going to pull the estate, we're going to find out in our title work who's authorized to sign and who needs to sign. So it's partly our job too to let you guys know that, okay, on the listing side, that, hey, these are all the people who need to sign. So The bonus question here, you're listing a property for this kind of goes over to marital rights a little bit here, but you're listing a property for a married person who inherited the property from her mother. Your seller informs you correctly that the property is considered separate property in North Carolina because it passed solely to her and it is not marital property. So that is correct. That is considered separate property under equitable distribution. Does your seller's spouse still need to sign the deed? It was just inherited, so separate property under North Carolina law.
To sell it, yeah.
Okay, I was trying to trick you. You can say the spouse still needs to sign. Believe me, the vast majority of the time the spouse needs to sign. So when in doubt, yeah, the spouse needs to sign.
Okay, one to buy, two to sell, one.
There you go. Keep that in your head. Absolutely. That's a good thing to repeat. There are very few circumstances where the spouse doesn't have to sign. And if your seller is married and they say, oh, my spouse doesn't have to sign, we have an agreement or something between the two of us. Or no, I inherited that property. It's just mine. Then that's when you need to say, whoa, whoa, whoa. What kind of agreement do you have that says the spouse doesn't have to sign? Because I need to get a copy of it. I need to send it to the closing attorney because we need to see like a notarized, recordable free trader or waiver of marital rights, separation agreement with waiver of marital rights. We need to see that document. So never take your seller's word that, oh, my spouse doesn't have to sign. We're separated, or I bought this property just in my name and we had a prenup. Well, let's see that prenup. It has to be notarized, it has to be recordable, and it has to have that waiver of marital rights in it.
I'm in a similar situation with a buyer. She bought a house a couple of years ago, and now
Right.
she's married.
Okay.
She wants to buy another property, but she doesn't want her husband to have interest in either of the properties.
Okay.
So they've gone and kind of talked things about it and got
Right.
documents signed. But if she was to sell both the properties, would he have to sign even though they have a legal document now that he has no interest in?
So it sounds like she needs two different type of documents because she's already bought one property.
Right.
So she needs a waiver of marital rights in that property, which will have to be signed by both parties, notarized and recorded.
Mm-hmm.
And then she needs a free trader agreement for future acquisitions. The free trader agreement will basically state that you are free to buy property in your name only, free and clear of your spouse's rights on all future acquired property.
That would be nationally and internationally all, or just?
You can do one for all. I mean, typically, if you see spouses who want to buy something just in their name and they don't want their spouse to have any rights in it, they can do a free trader, which will allow them both to buy properties free and clear of their rights. Now, we could also do two specific waiver of marital rights. So if this buyer wants their spouse's marital rights waived in the property they already bought, we do one for that, and then we do a specific waiver of marital rights for the future property they're going to buy, and that would apply just to that one property. So it just depends on what your client needs.
Now, you said something about internationally.
Yes,
So I
she
mean,
wants to buy more properties nationally and internationally.
so that would
This only applies to North Carolina. Yeah.
There you go.
You need to, so in each state, this real estate law is state specific. So in each state, she would need to contact a title company or a closing attorney there to get the right documentation for buying a property. A free trader recorded in North Carolina, it's only going to apply to North Carolina property. It's not going to carry over to buying something in South Carolina. So you need to make sure you advise that person. You need to speak with a real estate attorney in every state you're buying properties in to get those documents from. But we can, here in North Carolina, our office can always help with a free trader, waiver of marital rights, those type of agreements that your client may need. If they want to buy something free and clear of their spouse's marital rights, we can assist with the paperwork on that. It's usually around, free trader is about $100 or so to prepare. It's not expensive. So. All right. And another part to this bonus question, when you look at marital rights in North Carolina, it's not just equitable distribution. I've argued with family law attorneys. They're like, oh, this is a separate property. Fine, okay, separate property under equitable distribution. There's still like 4 or 5 more marital rights that attach to properties. The right to dissent from a will, the right to take an elective share. There's 3 or 4 more marital rights that attach to properties other than just equitable distribution. So that's another reason why the spouse has to sign in that bonus question. Alrighty, so we can flip over to the next page and we'll move from intestate to testate. So this is your property owner who does have a will. And in this situation, the property owner's last will and testament will dictate who gets the real property owned by the estate. So the will, here's what gets tricky with this part. The will must be probated in the county where the property is located. Or if the will is probated in another county or state, then the will must be at least filed or transcribed in the county where the property is located. So we'll say you're dealing with a seller. The owner of the property died, has a will. your first question would be, okay, has this will been probated? Have you started the probate process? Do you have an attorney helping you probate the estate? Is the executor probating the estate? Has it been probated? Second question is, where is it being probated? That's a key question as well. If they say it's a North Carolina property, but the person passed away in Florida and they're probating the estate in Florida, that's fine, but you've got to transcribe that probate into the county where the property is located. So if another example would be, you have a seller who has a beach house down in Wilmington, they die here in Raleigh, so the estate's probably being probated in Wake County, but that's not going to help with selling the property down in Wilmington. That's in a different county, so you've got to make sure that probate is being duplicated or transcribed to the other county. So that can get tricky there.
Is there a fee for that, just to get it duplicated?
There's a filing fee. You don't have to do the whole probate process twice.
Mm-hmm.
If you're doing it in another county or state, you just need to either file the will in the county where the property is located, or you can transcribe that probate into that county.
Okay.
Now, there would be some fees involved, but it wouldn't be probating the estate twice. You don't have to do the whole affidavit, notice creditors, all that again. It can be just done one time.
Wills aren't required to be recorded, are they?
They don't have to be recorded as registered deeds. They do not. But they do have to be probated. A will that has not been probated is pretty useless. So, at the very least, it has to be probated. It's probably actually a good time, too, to go ahead and kind of fill you in on just a little bit of what you need to know about the probate process. So, okay, we'll say you've asked the right questions. You've asked, okay, there was a will. Yes, there was. That will left the property to that person's 2 children. Okay, has it been probated? They're going to say, yes, the probate process has been started in the county where the property is located. We'll make it simple. So, Wake County property, probate's been started. So, at what point, let's see if I can answer this, at what point do you think you can sell that property out of that open estate? Just start the probate process and we're good. The will's been submitted. I think more steps. Yeah, more steps here.
To put that ad in the paper and talk about creditors.
You have to run the affidavit. That's correct. You have to run the affidavit notice creditors at least once. You do have to have your testamentary letters there. Obviously, if the will's been accepted and verified by the court, and they've issued what's called testamentary letters. Affidavit notice creditors has to be run once, and then the executor must join in the deed, even if it wasn't devised to them. So we'll say you've got the 2 children who are the devisees. You've got a separate person who's the executor. That executor must be willing to sign the deed as the executor of the estate. They're basically taking responsibility for, yes, there's enough assets in this estate. I'm the executor. I'm saying I'm agreeing to it being conveyed. And then that executor actually becomes personally liable if there's more debts than assets in the estate. So, and then we have what's called, and we prepare this, it's called an open estate indemnity agreement. The title insurance company requires it. That's something else the executor has to sign that basically states that, yes, we're indemnifying the closing attorney and the title insurance company that there are sufficient assets in this estate to pay any debts from the estate, any creditors. So that's where you get. So if you are, from a practical standpoint, if you're dealing with a seller, and you're under contract, and you're supposed to close in a couple of weeks, and they say, and you ask them that question, they say, probate, what's that? Then you're going to be delayed a little while because they still need to submit the will, run the affidavit notice to creditors at least once. I've seen estate attorneys pull that off in like 2 weeks or less, but you're still cutting it close. So definitely in that situation where you have an estate, make sure that it has to be that it's being probated. Follow-up question here: what if there's no will? So same scenario. This one person owns the property. We'll say they passed away 3 months ago, and you've gotten the listing. No will. So we're talking about who inherited it from them. We'll just say the 2 children, a spouse and 2 children inherited it. Do you still need to probate that estate? Because there's no will to submit.
Yeah, there's debt still.
You do. Still got to run the affidavit notice to creditors. Plus, there's a nice little form in there that says, after diligent inquiry, the people entitled to take from this estate are these people. We'd like to have that form. So there's one exception to that. If in a situation, I'll complicate too much, but a situation where someone's passed away 5 years ago and no one's done anything with the estate, and they own a house, and finally one of the family members just comes to you and says, oh, well, we finally gotten around to trying to clear this estate up. We want to sell this property. 5 years have gone by, no will. It has to be no will. If there's a will, that will has to be probated. No will. Then the title insurance company may say, okay, 5 years have gone by, no creditors have any rights, 2 years, statute of limitation. no creditor would have any right to make a claim against this estate because 5 years have gone by. Then we can probably sell, the heirs of the estate can sell, no probate, no executor, or no administrator when it's intestate, no probate, no administrator signing the deed. But the title company will require affidavits stating who are the heirs. So you usually have to find two people who know the family, who are not inheriting the property, who have to sign affidavits saying, oh, that's all right, I know this family. They had 2 surviving children, no living parents. So we have to verify who did inherit it. We're not just going to take the sellers. We're not going to take the person's word who's inheriting it. Oh yeah, I was the only daughter to my mom. I got it all, and then you find out there's 3 other disgruntled kids, who did get a fourth of the property. Don't want that to happen. So that's kind of one variation where you don't have to worry about probate. No will, more than 2 years have gone by. Obviously, go to the closing attorney, explain the situation to him. We'll prepare the affidavits. We'll do everything we need to do to help you get it sold. But, so key questions to ask your sellers when dealing with a deceased property owner: did the owner have a will or a trust? What county, state is the will probated in? Or what county, state is the estate file located in if it is an intestate estate? So as we just mentioned, in all likelihood, you have to probate the intestate estate as well, even if there's no will. If there is a will, then who are the devisees and are they married? Don't forget about spouses. They do have to sign when it's a will. If no will, then who are the heirs of the estate and are the heirs married? And then, of course, you need to know who the executor or the administrator of the estate is. An executor is when there's a will, because the will appoints who the executor is, and the administrator of the estate would be, if there's no will, that's the person who's is like the executor, but with no will and intestate. Consult with the closing attorney early in the process to identify who needs to sign the deed and in what capacity. It is pretty rare for the executor to have the sole power to convey the property. Usually the devisees, heirs, and their spouses have to sign the deed. If the property is in a trust, ask who the trustees are, and if the seller has a copy of the trust, or what's called a trust certification, to provide to the closing attorney. We covered 7 already. At what point in the probate process is the estate? So you would want to ask your seller, okay, you said it's been probated. How long ago did this get started? I mean, what point in the process are we? Did you just probate the will yesterday? Because then you know you're going to have some lag time. Is the estate open or closed? All likelihood it's probably still going to be open. In order to convey property out of an open estate, the affidavit of notice of creditors must have been run at least once. The executor must be willing to join in the deed and sign an open estate indemnity affidavit. So number 8, this is where things get really complicated. So if you run into this situation, you're going to have a delay on your hands. Are any of the devisees or heirs minors? So less than 18 years old. Anybody have any idea what you have to do if you've got minor children who inherited the property or received the property through a will? Put it in a trust, sort of. You actually have to take your purchase contract, submit it to the court, and you need an attorney to do this. So you'd have to hire an attorney, the seller would have to hire an attorney to do this for them. You actually have to submit the purchase contract to the court and get the court's approval for the sale. The court will appoint a guardian ad litem for the minors. They'll review everything, and you need a court order to sell that property. It's a special proceeding. So in a situation where you have devisees or heirs that are minors, not only are you worrying about the estate being probated, you have to worry about the special proceeding, which is the approval from the court. And why they do that is someone needs to protect those minors' interests. Even if the seller tells you, oh yeah, minor children did inherit part of the property, but I'm their guardian, I'm their legal guardian. Not good enough. Still got to go to the court, get the approval of the court. That's going to take time. So anytime you've got a minor child, and for that matter, also a incapacitated or mentally disabled person would qualify in the same department. You need court approval because the court wants to protect that minor's interest and make sure that there's not other adult owners who are taking advantage of them, selling the property off on a bad deal.
And they assign the guardian, the court assigns the guardian?
Or if they have a guardian already, they may approve that guardian to be the guardian. But the court you still have to have a court order approving the actual sale, which means the purchase contract has to be submitted to the court.
Now that's if it was willed or otherwise left
Doesn't
to.
matter.
Now if it's in a trust,
That can change things. If an estate plan is set up properly and they know there's going to be minor children, it may not go to that point. It may go to a point where it goes into a trust, and then that trust can act on behalf of the children to sell the property.
because there'll be some trustee that's making decisions.
Right.
Okay.
Right. So this is really just a situation where usually where an heir, where a minor inherits a property, no one's really done any estate work at all, and the 2 surviving children are minors. Then you've got a real complicated pretty lengthy situation. You probably need at least a month, 4 to 6 weeks to probably sort that out with the court and get the approval. The last part here is when things go wrong, and they usually do. Partition proceeding, this is when you deal with, let's say you're listing a property and 10 children inherited it. So you've got 10 children to deal with, and they're fighting like cats and dogs, and they hate each other. So that's probably not a listing you want to take anyway, but there is a way out of that.
Somebody's got to do it.
I was going to say, there's a way out of that, but they're going to need an attorney. They'll need to file what's called a partition proceeding. It's a special proceeding once again, and the court is going to step in and basically mediate between the parties, and they'll eventually give approval to sell, once they've kind of looked at every person's interest. And so there's a way around that. And the other situation that can get complicated is when the debts of the estate exceed the assets. So you've got an executor comes to you and says, well, yeah, we want to sell the property, but the estate is way in debt. We've got twice the amount of creditor payments than we do the assets of the estate. That property can also be sold, but once again, you have to get the court approved. You get court approval. The court will get involved. They'll figure out which creditors need to be paid from the proceeds, and you get a court order that allows the sale. So those are the three complicated situations: minors, multiple parties who can't agree on selling the property, they're fighting, and then the debts of the estate exceed the assets. Probably need the court involved in all three of those. You'll need to advise the seller to hire an attorney to assist them with that. So, alrighty, that covers the estate part. Now, I did want to pass these out to you. This is our. This is our This is our funds wiring policy. Mm-hmm. I know you've probably all been schooled in on wire fraud, but I did want to just pass that along to you. The real key to avoiding wire fraud is do not, under any circumstances, discuss proceeds, getting money to the attorney, your seller funds. Never discuss those over email. You want to never send an email that says, oh, how would you like to get your funds from this closing? That's a terrible email. You've just opened up a fraudster to jump in and intercede and say, oh, here's how the funds need to be distributed. Never use email to talk about seller proceeds. Never use email to talk about the buyer getting their money to the closing attorney. So this seems innocuous. You sent this email to your buyer. Oh, yeah, you need to contact the South Law Firm to figure out how you need to get their money to them. You'll need to wire it. It's over $20,000. That's a horrible email, because that just leaves the opportunity for someone who's hacked your email to jump in and act like they're the South Law Firm and give false wire instructions. Discuss that over the phone. I'll start with the seller. When you're representing a seller, our policy is we do not accept emailed wire instructions from you or the seller. They need to hand deliver wire instructions, or if we're sending the deed package remotely to them, our email will specify to them, you need to put your wire instructions in the packet and overnight it back to us with the deed. We're not going to let sellers call us with wire instructions, email wire instructions to us. So you need to make it very clear to your sellers that, and I'm sure a lot of attorneys are doing the same thing. I know one attorney's not doing not wiring funds to sellers any longer, which is a little extreme. But you need to tell your sellers that if you want that closing attorney to wire funds to you, when you go in to sign the deed, you bring those wire instructions with you. Or if you're overnighting the deed to the closing attorney, put them in there.
And is like a voided check sufficient, or does it need to be something different?
Voided check is fine. That's fine. We still don't want that email, just because we don't want anybody to try to alter it or do anything like that. And then you'll see here, get this policy to your buyer right off the bat, so they know the policy immediately. So when you first start out with a buyer, it's good to get this to them right away. So what we want to do with the buyers are only have them deal directly with our office. So you can say to your buyer, call them, your buyer, say you can call the South Law Firm and deal directly with them on getting their wire instructions for you wiring your funds to closing. And what we'll do is we'll talk to them on the phone, we'll get their email address, we'll use an encrypted email to email the buyer the wire instructions to send their funds to us, and we'll explicitly tell them to call back to our office before they send the funds to verify one last time. Don't trust phone numbers that are sent through email. That's another way this is done. So when we verify wire instructions at our office, like let's say we're going to be sending funds to another closing attorney because that seller is buying that day, we don't trust the phone numbers that are sent through the email. We'll go online, we'll verify their phone number independently, then we'll call the other law firm, we'll have the instructions in hand, hopefully they were sent encrypted to us, and we'll verify verbally with that law office, okay, these are your instructions. So you have to be wary of anything that's emailed. One of the worst ones I heard was somehow the buyer and seller got in contact with each other, even though there were agents involved. And once again, funds were discussed over email, which is a no-no. And a fraudster came in, acted like they were the seller, emailed the buyer and said, "Oh, here's how it works. You wire your funds to me on the day of closing." And of course, the buyer wires funds to a criminal. It was before that you couldn't get wired funds back. Now, if it's more than $50,000 and you contact the FBI within 24 hours, they can freeze the funds. You've got a 24-hour time frame. So if you have any idea that your buyer or seller was defrauded, have them contact the FBI field office immediately to freeze those funds. There's a 24-hour time frame there.
And we do have a new policy here where we have a wire fraud notice that I think I sent to you at one point, and that has to be submitted with all files.
Perfect. It's in the purchase contract now too.
It is. It's in your agency agreement. It's in the purchase contract. The attorney has one, and we have one.
Yeah.
We want to make sure that it does not fall back on you or on the firm. And so there are lots of opportunities for a buyer to be educated, but we have to be educated first. It all starts with us.
You're the first point of contact. So absolutely, you got to educate your buyers and sellers immediately. Because once emails start flying and you haven't discussed that with them, then they're subject to being.
They have a million things going on, and so they will forget. So you should have that disclosure signed when you're getting the agency agreement signed, but you should be discussing wire fraud again when you go under contract and again as you're leading up to closing. So
let me warn you about two other things. Do not act as a go-between. So never ask the closing attorney to send the wire instructions to you and then forward those to the buyer.
That is against choice residential policy.
That's a big no-no. You never want to be an intermediary there. If I send you encrypted wire instructions and then you print them out and you regularly email or you forward it or regularly email it to the seller or buyer, then you've defeated the point of the encryption. Plus, you don't want to be that go-between anyway. As I've discussed earlier, you don't want to be emailing on behalf of the buyer about funds anyway. So something to note. Also, be wary of printed out wire instructions that look like they were emailed. If I have a seller walks in and they say, "Oh, I'm hand-delivering my wire instructions," they hand them to me. I look at it and say, "Wait a second, this was emailed to you. By who? And was it secure?" So be wary of printing out an email and bringing it in. That's not a good idea either. So just be wary of both of those two things. So, but yeah, if you have any questions about wire fraud, you can contact my office. We have not been burned once. We are super vigilant about that. So sometimes we may be annoying about that, but we're being annoying for a reason. It's to protect your client's funds. So, alrighty, well, I've done